Hi, everybody. Good afternoon. Welcome to the webinar, Reaching a Verdict, Guiding the Jury's Response to the Evidence. My name is Eva Johnson. I'm a program coordinator at Equitass, the prosecutor's resource on violence against women, and I will be moderating today's webinar. This presentation will focus on the jury's attention on the evidence in a manner that accurately conveys the reality of sexual assault and assists jurors in rendering a fair and just verdict. Beginning with jury selection and continue through opening statements, presentation of evidence, and summation. Today's webinar is hosted by Equitass, and the written materials, including a copy of the PowerPoint presentation and the presenter's biography, will be emailed to you after the presentation. Equitass's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. Equitass's staff is comprised of former prosecutors with over 100 years of collective experience who conduct legal research, provide 24/7 case consultation, serve as mentors and instructors, and publish resources. Now I'll hand the presentation over to Patti.
Hi, everyone. This is Patti Powers. I'm an attorney advisor with Equitass. As we prepare to begin this webinar, I'm going to comment briefly on fair use. We try to draw from the creative expertise of others in the field, which governs this particular slide that we're all looking at now. I'm honored to have this opportunity to discuss work with you that I'm passionate about, the prosecution of sexual assault cases. And I want to introduce our discussion today with this question: how many times have we as prosecutors advanced a well-prepared and strong case to trial, and the jury is either undecided or sometimes unable to reach a verdict holding the offender accountable? Our focus today is on guiding the jury's response to evidence to help ensure their opportunity to reach a fair and just verdict. Our work begins with jury selection as we introduce the infrastructure for the evidence that we're going to present at trial. It's critical that we convey that we value the jurors or the panelists' life experience and allow them an opportunity to apply their life experience as they will analyze the victim's experience of the sexual assault. To do this, we're going to discuss asking questions that allow panelists to access and reflect upon their own life experience. These questions significantly are also going to lay the foundation for the evidence that we present at trial. One very effective way to do this is to develop a theme that resonates with common experience. Finally, we're going to explore the importance of maintaining a laser-like focus on the offender in jury selection and throughout trial. We, the jury, find the defendant guilty. Those of us who are prosecutors and trial attorneys will never forget these moments when the jury renders the verdict. These words also mark the fruition of our work, the efforts of law enforcement, and so many other involved service professionals, and certainly the courage of survivors who have allowed us the privilege of advancing their cases. We, the jury, how does our work begin? It begins with an initial review of our case and a trial perspective. Taking this kind of global view allows us to prepare with the orientation of how the evidence is going to fit together, how the evidence sometimes interlocks, as well as the true reality of the crime that the evidence reveals. Focus on physical, psychological, and physiological evidence is important in our efforts to try to forge a link between the panelist, the potential juror, with the victim's experience. Our work continues with encapsulating the evidence in a theme which is broad enough and flexible enough to allow us to fold in the evidence as it develops further during trial. What may have begun as a theme accentuating the defendant's control, he was in control, may develop into a sub-theme of the offender took away her options and she didn't stand a chance. We've learned also that the reality of the crime is also comprised in a deeper level of many features which have traditionally been viewed as weaknesses, perhaps in a case, or as challenges in a case. We know, though, that the reality of the crime is composed frequently of many of these features. As an example, delayed disclosure may come about because of the trauma that the offender has inflicted, or the victim's fear of the offender's return or potential retaliation. Other issues, including prior victimization, prior relationship, or even drug or alcohol involvement, may also be features of vulnerability that the offender knows of and that the offender has used when embarking upon the commission of this crime. So we're looking also at taking these issues and turning them into strengths at trial. It's important to always keep the offender in the picture. The victim is not on trial. The offender is on trial. And as prosecutors, we also are governed by our goal of maintaining fairness in all aspects of our interaction with the panel. This graphic illustrates the work that we do for a verdict, and it begins, as you can see, with jury selection. It continues on to the presentation of evidence and reaches its finality in the full force of its power as we summarize the evidence that we have presented for the jury. So it's about evidence, the evidence which establishes the elements of the crime, the offender's commission of the crime, and also significantly answers the jury's question about how this could have happened. We need to know the opening before we select the jury. We need to do this to be able to set the stage for the evidence that we're going to present. I'm going to look now at an example of an opening statement. On April the 3rd of 2015, this day began as a regular day for the victim. On that day at 7:00 a.m., she showered and dressed and went to work. She returned home to her apartment early with symptoms of the flu. She took some over-the-counter medication and sipped on some glasses of wine. She fell asleep on her couch in the living room from where she always watched television. On April 3rd of 2015, with her living room lights on, the darkness outside, she awakened with a jolt of reality, opening her eyes to a man who was suddenly on top of her. She felt shock and remembers freezing and her mind telling her that she was going to die. So as you absorb, as we all absorb this language from an opening statement, what do you think? Is the offender known or unknown to the victim? On this date, going further, she did not die. You're going to meet her in this trial when she testifies to every detail she could never forget. The fright, the nausea, the pain from his penetration of her body, and the extreme feeling of isolation and loneliness, with her heart threatening to explode through her chest. And let's return again to the question I asked you a moment ago. Is the offender known or unknown to the victim? The reality of this crime is that the offender could have been someone who was known or someone who was unknown. This particular example is from a case where the offender was unknown to the victim, but it represents so many others when someone the victim knew became a stranger. So we return to this critical question: how are we analyzing the evidence, and why is insight critical in our efforts? It's important that we allow the jury a full and fair opportunity to come to relate and to understand as deeply as possible the victim's experience of the crime. One powerful avenue of creating this kind of linkage comes about through focusing on the life experience of panelists in our efforts to present evidence in the case. The victim's experience may provide sometimes physical evidence of the crime. There may be physical injuries, there may be clothing that's been disrupted, or other evidence which comes about through the offender's commission of the crime. There may be psychological evidence as well, evidence of the victim's state of mind as the offender committed the crime. And there also may be physiological evidence in the victim's response to the terror of the crime that was committed against her or against him. It's critical to bear in mind that these are all important avenues of evidence in order to give the jury the fullest and deepest understanding of the victim's experience of the crime. And in this process, we need to come to recognize the true reality of the crime. The passage of time. This crime may have occurred many years ago, but the victim never forgot. He or she lived with every detail and every ramification of that crime over a long period of time. There may have been an initial delay in disclosure, but we need to turn to causation when we encounter this phenomena in our work. Who caused the delay in disclosure? So many times this delay has come about because of the trauma that the offender inflicted on the victim. The victim was unable to reach a decision to make that report in so many cases due to the conduct of the offender. And we all know that offenders may use alcohol and drugs as tools in the commission of a crime, and clearly an offender does not need to leave force or to cause any injury when alcohol is on board. Many of our cases involve victims and offenders who are acquaintances or who have been in some sort of relationship. And we know that in so many of these cases, the offender clearly knew the victim. The victim did not know the offender. In this very eloquent sense, the offender, even though known on some level by the victim, is in fact the stranger that so many members of our community, including our panelists, fear. So what are we up against? What are misperceptions of sexual assault that if left to continue, and if not scrutinized in our preparatory work for jury selection, may cause jurors to miss the reality of this crime? Well, we know as prosecutors and other allied service professionals that the reality of sexual assault, that weapons are not frequently used. They don't need to be used. In cases involving known offenders, clearly shock can be a tool or a weapon, and physical force is not needed. So injury is not commonplace in many of our sexual assault cases. Delay in disclosure is frequent, and in these cases we have come to understand that many victims are unable to make a report of sexual assault due to the trauma or the threats or the potential retaliation exercised by the offender in the commission of the crime as well as his aftermath. We also know that offenders do in fact use drugs and alcohol very frequently to facilitate the sexual assault, and that offenders also will focus on a victim's vulnerability or sometimes even try to create symptoms of vulnerability. Victims respond to trauma in a myriad of different ways, and it's important that we come to understand the experience of every individual victim without resorting to generalizations, because trauma certainly is a unique aspect of victimization for the victims that we're privileged to work with. We know from the testing of untested rape kits throughout our country that there is a significant incidence of serial or repeat offenders in both groups where the offenders are known to victims and also when the offenders are unknown to the victims. We also are becoming increasingly acquainted with the reality that some offenders are also crossover offenders, meaning that an offender may sexually assault someone that the offender knows, as well as a victim that the offender does not know. So there is danger in both of these categories of perpetrators, and many members of our community are only becoming initially acquainted with the reality of this crime that you and I as prosecutors and allied professionals know. And we also know that time does not erase traumatic memories. And it's important to focus on this because trauma is still a feature of sexual assault in many cases, even if drugs or alcohol are involved. So we need to focus on scrutinizing offender behavior and making sure that we're focusing on the offender in all areas of trial, including jury selection. Diving deeper into the evidence as we prepare to embark on jury selection gives us the opportunity to focus in detail on the evidence that we have of predatory conduct. All of us know that rape is a crime that is premeditated to some degree for at least more than a moment in time. Most offenders certainly do not want to commit a crime to be successfully apprehended, and there is some thought given to the commission of the crime at an earlier point. So we need to carefully examine the evidence that we have of predatory conduct involving premeditation and planning of the sexual assault. And we'll ask this question in our process. Did the offender exploit a vulnerability that the offender knew or a perceived vulnerability? In many acquaintances and relationships, a victim will confide a great deal of personal information in an offender, a victim's history, her sensitivities, or his sensitivities. But in any event, vulnerability is a function of information that an offender may very easily and adroitly be able to capture in an acquaintance or a relationship. In a case where the offender is unknown to the victim, the vulnerability may be an ostensible vulnerability. It may also be a geographic situation where a victim is alone without any kind of support system at a late hour of the night or during the early morning, and an offender who's been stalking the victim is aware of this information. And then finally, we also looked at this question: was the offender relying on misperceptions involving the use of alcohol or drugs? And it's important that we remember offenders are part of the general community, and the misperceptions that we know exist in terms of how jurors and members of our community perceive victimization, offenders, and victims is also information that offenders absorb as well. But the key for us as we embark upon our preparation, our path to jury selection, is to analyze and to convey in our questions and throughout the trial the effect of the offender's conduct on the victim. Clearly, the offender caused victimization, and at all times we need to make sure that that link is well known by all involved. If ever there were a formula for offenders targeting victims, this is it. And this formula represents offender conduct with both victims that the offender knows as well as victims that the offender has not previously known. Accessibility. How much greater accessibility to an offender is a victim who's in a relationship or has some kind of acquaintance with the offender? The victim is right there and is clearly accessible to the offender. In the case of an offender who is unknown to the victim, it may be geographic. An offender may have stalked a victim and be aware of the victim's habits on leaving work at a certain time, going to a parked vehicle, taking a bus to get home, or other activities. But accessibility is a key feature. The second component is vulnerability. And as we touched on just a moment ago, the vulnerability can be something that is known by the offender because the victim has confided information or it can be something that is sensed by the offender in a relationship or an acquaintance with the victim, or it may be something that is ostensible and an offender can know whether he or she knows the victim or not. The third component is credibility. And it's not our conception of the credibility of the victim. It's how the offender perceives credibility. Remember how we touched just a moment ago on how offenders are certainly part of the community as well, in a sense, and they come to know the misperceptions that are generated among members of our community. An example of this might be a case of alcohol-facilitated sexual assault. And an offender may well say to a victim, go ahead and report this crime. Go ahead and try to call the police. Do you really think they're going to take your call? And if they do, no one's going to be able to understand you. You're drunk. You're intoxicated. So when we look at these features, it's very important for the work that we do analytically so that we can present the true reality of our crime at trial. And it also is important to focus in depth on this formula as we prepare for jury selection. So these are some questions that could be asked to focus on accessibility, vulnerability, and credibility. Now, we're aware that in not every jurisdiction can prosecutors ask questions, but sometimes there is an opportunity to ask the judge to ask certain questions of the panel. So let's think about this globally and try to determine a way to use this information in questions. And certainly, these may be questions that could be asked rhetorically in a closing argument, depending upon how this case is presented at trial in terms of evidence. But accessibility. The evidence will establish that the victim was in a relationship or knew the offender for some period of time. Can you consider evidence of a crime in the context of a relationship? What's important about this question is that we're focusing on evidence of the crime that can occur in a relationship or an acquaintance. A question regarding vulnerability. Have you ever had a confidence betrayed? We're asking the jurors to reach into their life experience and to determine whether they have had this experience. Have you shared information with someone you trusted who betrayed that confidence? Can you see the offender focus in these questions? Although not stated, it certainly is implied. Credibility. As a potential juror, you're the judge of credibility in this case. Are you able to fairly decide credibility in the context of a person's vulnerability? And again, we're laying the foundation for the presentation of evidence of vulnerability as we embark to trial. As I mentioned a moment ago, offenders will create or sometimes aggravate symptoms to use against the victim. And these are only a few features that offenders will focus on in trying to cast questioning upon a credibility of a victim. This is how we examine our case in detail. Although many of our jurisdictions do not require a showing of intent, it's information that the jury will find useful. So we look at the defendant's intent, how the victim was selected, accessibility, vulnerability, the offender conception of credibility, evidence of premeditation or planning, or sometimes manipulation or coercion. We present evidence about the sexual assault, the exit strategy that the offender used, and then trial testimony or trial strategy. And we're looking very carefully at each of these. Our goal is to lead jurors. We want to help them to understand the dynamics of offender conduct as we lay the foundation in jury selection, to recognize how victims are impacted, and to come to understand the danger of offenders in relationships and acquaintances as well as unknown offenders, and to recognize again that for victims of sexual assault, the effects of the crime do not go away over time. We need to mention also it's important to analyze the defense, and the defense questions of the panel can also give us important clues as to a theory or perhaps even a goal with the panel before a closing argument. So looking at the defense questions, we want to ask, how is the defense advancing their theory? And sometimes the defense questions are going to require a subtle response from us in the questions that we frame. So we need to be prepared to incorporate new questions into our opportunity at voir dire. So turning now to voir dire, we're leaders in the courtroom. And if we're in a jurisdiction where we can ask the questions, a conversational approach to communication may be an excellent vehicle to put the panelists at ease to the extent that it's possible. We'll be watching for their reactions to our questions, and we'll be respectful as prosecutors regardless of what the answer is. So let's look at some examples of questions that we can ask the panel. Here's a question that relates to delayed disclosure, and as we've discussed, this is a very common dimension of victimization. How many of us have had a traumatic event occur earlier in our lives or years ago? And I'm not going to ask you to describe for your fellow members of the panel what that event was unless you'd like to speak about it. And as we're asking that question, we know that the victim is a person who's not given an opportunity to not talk about trauma. So another question might be, were you able to talk about it right after it happened? Did you ever forget it? Do you still remember the details? Offering the jurors, the potential jurors, an opportunity at a later time to connect with the victim's reasons for a delayed disclosure and how the impact of trauma conditioned a victim's ability to come forward. With offenders known to the victim, have you ever experienced a situation where you thought you knew a person and then realized that you didn't know him or her after all? How did you feel about that when you thought you knew this person? This is at the core of the testimony of so many victims of sexual assault who knew the offender and who were utterly shocked by the offender's attack. Many victims will, in fact, say, I thought I knew this person, but I realized I didn't. And we go back to the reality of a thing. The victim thought she knew the offender but did not. He was a stranger. Expert testimony, if we anticipate presenting it, we may want to ask this question. Have you ever had a reaction or response to something very upsetting or traumatic that occurred in your life that people close to you didn't really understand? Were you able to explain how you felt? Again, pointing to a potential basis for expert testimony if we're going to offer it in our case. Another question, do you have any expectation about how another person might react after a traumatic event? Do you think that a person who's been sexually assaulted would behave a certain way after that happened? Would you be able to fairly hear and evaluate testimony that explains a person's reaction to a traumatic event? Expert testimony in trauma, we will have made these decisions prior to trial, but we take a look at what the juror expectations are, if it's a response that needs further explanation, and provide to the jurors context, which sometimes is very helpful in understanding a victim's response to trauma. These are all important considerations pre-trial, and these are just some of the areas that may obviate our decision to provide expert testimony. A question regarding consent. Based on your life experience, do you have to agree to do something that somebody else wants, or are you free to make up your mind? Very few members of the panel will ever respond that you have to do something simply because another person wants you to. What if you had originally decided to do something? Can you change your mind, or once that decision is made, is there no turning back? Do other people get to make your decisions? Again, these questions all relate to an opportunity to freely give consent or to modify any kind of initial agreement that may have been made in a case. And this is how the consent defense looks. There are questions or challenges by the defendant to the victim's credibility, the ability to form and maintain a memory, and what, if any, motivation there is. So it's important to ask questions directed to the panelist's experience in a very early effort to be able to overcome the consent defense. So overcoming a consent defense, just a note about that, we'll focus on a disclosure that persisted over time. During the trial, we fold in the corroborating evidence and the vitality of this disclosure, as we discussed earlier, through the presentation of sensory information, psychological and physiological detail. All of this running to demonstrate a lack of any negative motivation. A question regarding alcohol when it's at issue in one of our cases. You're going to hear evidence involving the consumption and the impact of alcohol. Now you'll notice we're not just asking the question about consuming alcohol or drinking, but we're using that conjunctive word "and" in a very important sense, consumption and impact. Are you able to listen carefully to this evidence and determine how alcohol was used? Again, a word that bespeaks predatory involvement, which will be developed further in trial. If a person's judgment is impaired by alcohol, does that give anyone a license to harm or hurt them? Another question pointing to predatory involvement. Homelessness, if this is a facet of the case. You're going to learn during the presentation of the evidence that a victim was homeless during the time of this crime. Have you experienced this life challenge or known someone who was homeless without any place to stay? Are you able to listen to this testimony and determine if homelessness played a role in the events that you're going to hear described? We're focusing now on an apparent vulnerability with the evidence to follow in our case. Witness list and prior experience. The court has read to you a list of witnesses who may testify in this trial. Among those persons, and the court has read the list of names to you, are forensic scientists, a counselor, medical professionals, law enforcement, and laypersons. Is there any category of witnesses that you would be unable to listen to fairly based upon an experience that you've had? Some persons may have had an interaction with law enforcement that give them considerable difficulty. This is one way to approach that kind of a situation without focusing on any one profession or any service professional, to give the panelists an opportunity to describe any impact which may possibly impede their ability to be fair and impartial. A question regarding the work of the jury. Based on your personal and/or work experience, how do you feel about problem solving just in terms of your everyday life? This is a question that always assists panelists in being able to speak about another everyday life experience. Whether the person works in a business office or works at home, we all experience problem solving on a daily basis. And the information that panelists provide in this regard can also give us important information about their ability to do the work of a juror. Is it important to you to try to mediate or help people out when there's an argument? Are you comfortable or uncomfortable with this role? If you had a strong opinion, would you be open to discussing it with others who disagree, maybe even changing your opinion? If you were convinced that you were right, would you be willing to change your opinion? In this discussion also, we're able to inquire about some very important components of problem solving and forming opinions, and one of them is listening. And this is also a question that can be asked during this general conversation. The fairness question, I think, is important for us as prosecutors. If we, representing the state, our jurisdiction, establish the elements of the crime beyond a reasonable doubt, is there any reason that you would be unable or maybe reluctant to hold the defendant accountable for his conduct or her conduct and find him or her guilty? And I think we also need to ask this second question because it's fair. At the same time, if representing our jurisdiction, we do not establish the elements of the crime beyond a reasonable doubt, would you be unable or reluctant to find the defendant not guilty? And you would be doing your job also if you reach this opinion. A concluding question might be, you know yourselves better than anyone else. Does anyone present have any life experience or strongly held belief or something that occurred in your personal experience that perhaps no one else knows that in any way would impact your ability to fairly and impartially decide this case based upon the evidence? We've taken just a few examples of experiential questions that can be asked. It also bears mentioning that we need to know our jury selection system and the process for peremptory challenges in the courtroom that we're in. We need to prepare in advance for challenges for cause and consider that on any of our panels there may be a dissident panelist, and this challenge may come up very quickly. At all times, our commitment is to represent prosecutorial leadership in this litigation. There is some importance in also recognizing group dynamics that we might see on the jury panel, and this graphic focuses on the role of leadership and how that leadership may play out given the responses that the panelist is making to other questions. The same with the person who is more likely to follow. Again, we need to carefully evaluate their answers to the questions. Let's touch now upon Batson challenges, defending a Batson challenge. First of all, as prosecutors, we're going to take good faith peremptory challenges and prepare to justify them if it's necessary. It's important to take the time that we need in questioning the panelists. If there are behavioral observations that are giving us concern, we need to state them clearly on the record if they form part of the concern so that we can have a record to focus on if this Batson challenge is brought based upon our use of a peremptory. Maintaining notes is important because we want to make sure that we're touching on all areas of concern that we have with the panelists in question. If we're going to raise the Batson challenge, first of all, we want to take a very careful look at the composition of the panel within the range of peremptory challenges. If a concern develops during the defense inquiry of the panelists, if at all possible, we should ask questions to rehabilitate and to ask the questions that need to be asked if for example, they were not asked by defense counsel. We're going to be looking for a pattern of strikes or object on the basis of one strike. We need to consider whether there is necessity in the defense peremptory as opposed to an unfair striking of a member of a cognizable class. And we know that we can bring the motion at any time before seating of the jury. We will, when we're bringing the challenge, we know that we need to establish a prima facie case of purposeful discrimination and identify the panelist as a member of a protected cognizable group. Our argument is basically going to be that membership in this group and the relevant circumstances creates an inference that the strike really is based on membership as opposed to any good faith basis. We may include questions that were asked in voir dire or maybe questions that were not asked of a member of a protected class but were asked of other panelists. This may be very probative of a discriminatory intent. The burden to show the discriminatory intent rests with and doesn't shift from the opponent. So we need to carefully consider this as well. As I mentioned a moment ago, sometimes we'll encounter a dissident panelist. And a person may have an agenda that's totally unknown to us as well as other members of the panel. Still, we're going to listen fairly and confidently. It's important also to try to gauge reactions and whether or not there's discomfort of other panelists. when this dissident panelist makes known their area of concern. And we need to restate the area of concern and thank this individual for raising the concern. And then after discussing that, we will inquire if it's possible, notwithstanding the issue that's been raised, for this person to fairly decide the case. And then we can confidently proceed to address the court with the challenge for cause. At all times, we remain leaders in litigation, and demonstrate at all times to the court our integrity and the integrity of the process. So a brief review of challenges for cause. They're done in open court, on the record, with the defendant present. The objection should be framed based upon a core of concern for fairness and impartiality while respecting the candor that the panelist has shown. We also need to be aware of the context of the objection and the reactions of other members of the panel, whether there are other people present that may be agreeing or disagreeing with the concern that's been raised. Juror questionnaires can be excellent avenues for obtaining additional information if you're allowed to use them in your jurisdiction. They can save time, and they really do help inform our work during jury selection. Many of them are very abbreviated, although they can be lengthier in major litigation. If you have any questions or need to discuss juror questionnaires, we at Equitass are very happy to help you with this, as well as many of the other areas that we've been discussing in this webinar. The questionnaires, the answers may lead to agreed strikes of the jurors, but it's really important to make certain that the defendant is present, even if a panelist is going to be struck by the court or by agreement, to try to avoid any problems based upon the defendant's absence. This is a graphic that just illustrates some of the key information that we can obtain from the jury in terms of questionnaires that, again, helps inform many of the questions that we're going to ask and helps us to prepare for the jury selection process. These are basic questions from questionnaires that are very helpful. Have you, a close friend or family member, been the victim of sexual assault? Do you have information about this sexual assault? Have you, a close friend or a family member, ever been accused of a sexual assault? And do you have information about it? You know, it's interesting when these questions are asked orally, as well as on questionnaires, how widespread sexual assault is. So many people on the panel will raise their hands and indicate that they have been victimized by an offender, or a close friend or a family member has. This is a question, though, that can be asked on a questionnaire as well as orally in many jurisdictions. So looking at jurisdictional practice, one of the things that we need to know in advance is whether we can ask this question of the panel or whether it's a question that would be asked on the questionnaire. It is an opportunity for the panel to be informed about how pervasive sexual assault is and what the impact is. If the sexual assault was reported or not, whether it was handled fairly in an investigation, and can the panelists decide this case, just based on the evidence provided in this courtroom. These are all very important considerations in sexual assault trials. This gives some additional insight into it, and we want to make sure that we're also determining if a person has been accused of sexual assault. If we're asking about this in open, that our focus is on the fairness of the investigation and the fairness of treatment, and certainly whether this person is in a position to fairly hear and decide the case. Using we and us whenever possible is a very important feature of our leadership as prosecutors and jury selection, because we all are in this together. And at no time do we want to separate ourselves from the panel or from the jury. So using that word we or us is important because it signals our respect for our fellow citizens who are panelists and who are potentially jurors, and then when they are jurors, and we are all in this together. Unfailing professionalism to the panelists, opposing counsel, the court, and the court staff is part of who we are as prosecutors, and our organization also speaks to that. So building the case, what we come into jury selection with is this kind of understanding in depth of the victim's experience, what the victim's expectation was on that particular day when the victim was sexually assaulted, the sensory, emotional, and physiological evidence of the crime. To give you an example of how this can be presented in trial, a victim testified on the stand that the offender came toward her and took his hand and pressed it into her neck. And I asked the victim, when the offender pressed his hand into her neck, as she described, if she was able to tell us how that felt. And her response was that she could almost feel the offender's hand on the back of her neck. That was clearly a traumatized sense of touch. And I proceeded to ask the victim further, are you able to tell us what was in your mind at that point? And the victim responded, as so many victims of sexual assault do respond, whether the offender is known or unknown. I thought I was going to die. I thought he was going to kill me. And I asked then if she was able to describe any thoughts or any feelings that she had then, and she said that although it was light, she felt a darkness, and it became difficult to breathe, providing physiological evidence of the crime. What was the victim's response to the moment when someone that she thought she knew or he thought she knew became an offender, became the stranger? What was life like after the sexual assault, after the victim was able? And that word is really important because able is the infrastructure for trauma. And then in some cases, the time for waiting, some cases years of waiting. We touched earlier on expert testimony, so I want to focus now very briefly on the power of evidence-based themes and bringing it all together in cold cases as well as current cases. And you'll note the offender focus in these themes, which also brings into our attention the victim's experience as well. On that day, he became a stranger she never knew. He attacked every vulnerability, and time did not erase her memory. The offender had absolute control, and the victim had no options. The offender did not need a weapon because the offender had the impact of shock. And so when we proceed to closing, what we're doing is bringing forward all of the vestiges of the offender's conduct and how the offender caused victimization. We're going to summarize all of the evidence that's been presented, providing expert testimony to support victim and witness testimony when it's necessary. And in this process, our goal is to help the jury to connect with the victim's experience. And that began early on in the jury selection process when we valued jurors, potential jurors or panelists' life experience by allowing them to access that life experience, and then later on they'll be attempting to place themselves in the position of a victim through the sensory, the psychological, and the physiological detail to come to understand the victim's experience of the crime. Using the themes that we've discussed can also help us to encapsulate the power and the core reality of these crimes for the jury in summation. So as we approach closing argument, with this kind of a focus on the valuing of jurors, panelists' life experience, laying the infrastructure or the foundation for our presentation of evidence by asking the panel to access their own life experience, we underscore the impact and the significance of all of the evidence of victimization that we're able to present at trial. And as we do this, our focus is that the evidence that the jury saw, the jury heard, and the jury experienced They have seen and heard this evidence more eloquently than we can summarize in our closing argument. Focus on physical evidence, psychological evidence, and physiological evidence allows a panelist and it allows a juror to try to understand how this could have happened to the victim. That's the critical question that so many jurors have in our cases. How could this have happened? They were in an acquaintance. They had a relationship. How could this have happened with that level of familiarity? We're able to provide that answer when we present the evidence of this crime. The victim thought she knew the offender, but she did not. The offender is the stranger. The offender is the stranger that our community fears and that many members of our jury fear as well. And I go back to the example of an opening. We need to know our opening before we select the jury and embark upon accessing their life experience. But at all times, we need to make certain that in our opening and throughout the trial that we are focusing on the true reality of this crime for the victim. Regardless of whether this crime involves a delayed disclosure, regardless of whether a victim had previously been a victim of sexual assault, regardless of the use of alcohol or drugs, which many times is coerced, although it may look voluntary on the surface, so many times there is coercion by offenders. But putting this all together, we need to make certain that we are representing to our fellow citizens, to our jurors, the true reality of this crime. And at all times, we want to very carefully keep in the picture. It is the offender caused victimization. With this kind of behavioral focus and this kind of evidence, remember that the evidence that the jury has experienced, they have done so more eloquently than we are actually summarizing in our closing argument. This is a quotation from Emily Doe that underscores the great significance and the importance of our work as prosecutors and trial attorneys. From Emily Doe: "When I was told to be prepared in case we didn't win, I said, I can't prepare for that. He was guilty the minute I woke up. No one can talk me out of the hurt that he caused me." Going forward, in an effort to do our best work for victims of sexual assault, we want to make sure that we are connecting the jury with the victim's experience, beginning with that very important step in litigation, jury selection. At all times, our focus is going to be on how the offender's predatory conduct affected the victim. The victim is not on trial and cannot be on trial. It is the offender who's on trial, so we always have to draw that link back from victimization to causation with the offender. We're going to lay the foundation for expert testimony to make sure that we're providing jurors with the depth and context for evidence that they need in this process. And early on, we can address a need for expert testimony when we ask questions of the jurors, many of whom, if not most of whom, have suffered traumatic events in their life and have experience with it, and also have experience with sometimes great difficulty in being able, if ever, to discuss it with someone else. So in the last analysis, we're going to focus on jury selection as a link to opening and closing argument that culminates in a verdict which respects the reality of the crime. And to do this, we know we need to inform the jurors' response to evidence, and we begin this process during jury selection. Thank you so much for being with us today. We're honored by your participation, and if there are any questions or comments, I would love to hear from you now. And my colleagues and I would also be very happy to hear from you with any other questions or needs that you have. Thank you.
I would quickly like to jump in and say that thank you to our presenter and for all of you in attendance for your participation and your dedication to increasing victim safety and offender accountability in your communities and across the country. When it's available, we will send you the link in the recording along with a copy of the PowerPoint, a presentation, and Patti's biography. Please remember Equitass is a 24/7 technical assistance provider available to respond to your questions, concerns, and training needs as they relate to prosecution and violence against women. On behalf of Equitass, thank you for participating in today's webinar.